Welcome to Regulating Artificial Intelligence in Canada and the US. We're going to cover some recent developments. I'll just get the housekeeping out of the way as people join. Clearly, this is a popular topic. We had over 300 registrants for this. Not bad for a sunny summer day. So thank you. Those of you who know me know I'm Kirsten Thompson. I'm a partner in the Toronto office, and I lead the Canadian Privacy and Cybersecurity Group. I'm joined today by Peter Stockberger, my counterpart and the office managing partner in our San Diego office. And we will be bringing you both perspectives on developments in AI. So we're really going to be discussing the growth of regulation in AI. And for anybody who follows this area, you'll know that it's sort of evolving quickly and in a patchwork, fragmented kind of way. So we're going to try and stitch this all together, make some sense of it, and compare and contrast across the border here. So we'll start with Canada because Canada's on top and better. No offense, Peter. You'll have your chance.
Highly debatable.
So next slide. So as I mentioned, AI in Canada is pretty typical of what we're seeing. It's fragmented. It is, however, developing very quickly. So we're seeing lots of regulatory developments. And the first real push on this was in our public sector, with the federal government releasing its directive on automated decision making in 2019, and that is now, it came in, compliance was required by 2020. And that really imposed various requirements related to risk management around the use of AI by the federal government. Private sector kind of lagged. In 2021, Bill 64 in Quebec addressed automated processing, and that provision will come into effect in September 2023. And for those of you that aren't aware, Bill 64 is the bill that substantially rewrote Quebec's privacy legislation. We also had Bill C-11, which purported to rewrite the Canadian federal legislation, privacy legislation. That died and then was reintroduced largely recently as Bill C-27. And it rewrites the federal privacy law and introduces a new federal artificial intelligence law for the private sector. And that's a pretty remarkable development, both in North America and especially in Canada. C-27 also introduced automated decision-making provisions in the privacy-related provisions of that bill. But I really want to focus on what would be a new artificial intelligence law, assuming the bill will pass, and it's likely to pass. Next slide.
Hey, Kirsten, out of curiosity, what's the impetus in Canada for these new regulatory efforts? I know, for example, in the US, we have different motivations at the state and federal level. The main motivation that we're seeing at the state and federal level is elimination of bias, in employment, in hiring, in offering products and services. Is that the similar motivation in Canada, or is there a different mindset, different philosophy behind these developments?
That's an excellent question. If you read the text of the Artificial Intelligence and Data Act, or AIDA, it primarily addresses bias, discrimination, harms to natural persons. So the motivation is quite similar. Although if you start reading between the lines, you start seeing some regulation of content and decision making. The government is obviously the key player that there was a drive to regulate the use of AI by government for inequitable outcomes in tax and employment and things like that, and that is now being moved to the private sector. Some of it is also the insidiousness of some of the deep fakes and false news, misinformation, that kind of thing as well. So I'm going to go through AIDA, as I've mentioned, in some detail, just so that everyone on the call can understand what their obligations and risks would be. But at a high level, what the themes are, as Peter mentioned, it's really concerned about bias, discrimination, and harms. And it's harms to natural persons. So apparently it's going to be fair game to use artificial intelligence against your competitors. However, having said that, AIDA won't get you, the Competition Bureau might. So this is really focused on harms to natural persons. It also draws a distinction, like we've seen in the EU, between what we can call ordinary AI and high impact or high risk AI. And because of the peculiar structure of Canada as a constitutional democracy, where there's a division of powers, it's limited to activities carried out in the course of international or intra-provincial trade or commerce. That's what makes it constitutional. So this will not capture AI activities that are wholly within a province. It'll be up to the provinces to pass those types of laws. And disappointingly or encouragingly, depending upon your perspective, AIDA is a pretty bare bones piece of legislation at this point, or bill. It's really just a framework. The real meat of it is going to be in regulations, and we don't have those passed yet, and there are no draft regulations available. But AIDA essentially regulates in 4 areas: governance, transparency, a whole whack around ministerial orders, and then finally, everybody's favorite discussion, penalties. On to the next slide. So before I cover those 4 topics, I do want to talk about definitions, because definitions are going to be important here. And I don't propose to go through this sentence by sentence. I just want to touch on some of this. You will, in the materials afterwards, be available, get this material, and you can go through it sentence by sentence. But whether or not you're in or out of this legislation is really going to be important. And that's really found in the definitions piece of it. So the first definition is obviously going to be what the heck is an artificial intelligence system? And the definition isn't surprisingly, but I want to draw your attention to the fact that it covers both autonomous or partly autonomous processes. So human in the loop fixes to get out of things like the EU provisions are not going to work here. Note that it's also restricted to processing data related to human activities. And I expect that Peter and I could have an hours-long debate about what is or isn't a data related to human activities. So that's going to be a bit of a squishy area. Then there's some technologies listed. Note this other provision. It's the use of the AI system to generate content or make decisions, recommendations, or predictions. And the make decisions, recommendations, or predictions is pretty standard in what we're seeing globally. Generating content is kind of an interesting one. What does that mean? So it appears to suggest that any content that's generated, whether or not you're making a decision or a recommendation or prediction from it, could potentially be caught by this. So it's racking my brains trying to think about what that could be. And I hit upon the deepfake phenomena. So that would be content that would arguably be caught by this. And then the other definition is biased output, and that's one of the harms that or the evils that the legislation purports to address. Again, not a lot of surprise there. The benchmarking is as against the Canadian Human Rights Act. So any decision, recommendation, or prediction or content that differentiates or discriminates on the basis of a protected grounds. Interestingly, the Canadian Human Rights Act does not explicitly set out political belief as a covered prohibited ground of discrimination. So that doesn't address some of the democratic concerns, the democratic process concerns that have been discussed globally. And finally, because this is fundamentally a bill that aims at addressing harm, we have to understand what harm is. Pretty broad, physical or psychological harm. Psychological harm is always a tricky one. Damage to an individual's property and economic loss. So that covers pretty much everything.
Kirsten, I had a question about a line there in the biased output definition around without justification. This line that says you can't adversely differentiate directly or indirectly without justification. And I'll give you an example of what I've seen in the US sometimes is you'll see some companies use artificial intelligence to make different product offerings to different categories of individuals based on protected characteristics. So for example, if a company says, well, we want to make sure that a historically disadvantaged community, let's say African Americans in a particular part of a city or Latin American population, we're going to offer them additional products, maybe additional discounts to get them in the door on financial services, for example. So by definition, the system is differentiating based on a protected characteristic. In the US, we don't have this concept in the law between a good differentiation and a bad differentiation. It's any differentiation if there's economic loss. could be the basis. But this line here without justification is interesting, because in that scenario, if you are using differentiation to potentially have a positive impact on a member of the community, is that with justification? I don't know if the bill has spoken to that, or if you have some thoughts on that.
It does, and you've kind of hit on the key issue, but we go about it differently. So there's a provision, and I haven't repeated it here, but it essentially says that this differentiation is okay where you're using that differentiation to alleviate some disadvantage or discriminatory behavior or action. So that would address what you're talking about. But the without justification likely means something different. And I'm thinking where there's a statutory justification. So for instance, insurers and insurance companies are allowed to discriminate on the basis of age or sex in setting risk-based insurance rates. So that would be an example of something with justification. So not quite what you're getting at, but a very good point. And I think this section will probably be subject to a lot of scrutiny in the bill and may well be revised, because as you correctly point out, it's very hard to discriminate or differentiate between the good discrimination and the bad discrimination. Next slide, please. So a little more on definitions. The locus of control of the bill is really two types of people: a person who carries out a regulated activity, or a person responsible for an AI system. And this is going to be really important in this bill, because which one you are is going to be associated with risks, penalties, and obligations. So obviously, this language may change or be modified as the bill makes its way through Parliament, but in the context of drafting contracts and arranging vendor relationships, it's going to be important to understand what it is you're doing, because your risk and your obligations is going to vary. And note that it captures, both these definitions capture processing or making available for use data related to human activities in the first one, and managing operations. So that if you develop the AI or if you manage the AI, you're caught. So that may come as a surprise to companies who are purchasing AI-mediated applications and software. And as I mentioned, AIDA also distinguishes between sort of the ordinary AI and high-impact systems. They don't tell you what a high-impact system is, except to say that stay tuned, it's coming in the regulations. And I would be very surprised if it didn't look a lot like what we see in the EU, which uses the definition of high-risk systems. And I've listed them there.
Kirsten, a quick question on this. If, for example, I'm a company and I hire another company to perform analytics on my sales staff, for example, and they have a software where my sales staff can go in, log on, record themselves giving a sales pitch, and this software will feed me back analytics about personality traits, how often I'm smiling, which hopefully is not too much because that's creepy, how effective I am at communicating my point. And so they're using some level of automated decision-making to feed back those points. Under this definition, then, myself as the business who's making available my employees, as well as the software vendor, would be covered under this bill. And is that true even though it's a business-to-business relationship, because we're talking about human persons as the employees? Am I reading that right?
You are reading that right. It does seem to capture the developer of the software, the employer as a manager, or making available the data related to human activities. So it's quite a broad sweep, and I think that's going to be some problematic language that we may see tinkered with. And the context you give is interesting as well, because in Canada, employment is a provincial jurisdiction. So it's unclear how the use of an AI system, as you discussed, would be regulated by this legislation. I think that would fall to the provinces. So it would be interesting to see how that debate and the commentary we see around that. Next slide. Okay, as I mentioned, there's sort of four buckets that AIDA covers, and I'm going to cover the governance one first. And so this is essentially regulates what you can and can't do and how you have to document it. So the first thing you have to do if you're going to have an AI system is to determine whether or not it is a high impact system. And that falls to the person who is responsible. And this is what I meant about those obligations and risks falling to one or the other of those two types of persons. And I've highlighted it in blue here, so you can get a sense of who is responsible for what. So you do need to know which category you're in for what purposes. So what you have to determine first whether or not it's a high impact system. How do you do that? Well, that'll be in the regulations when they come. If it is a high impact system, then you have to step up with some monitoring and risk management. And again, we'll know more about that in the regulations as to what will be covered, but not a lot of surprise. It's focused on risk management and monitoring of the measures to manage those risks. Data anonymization applies to anyone carrying out the regulated activity. And we've got the same language there. It's processes or makes available that uses the anonymized data. And really what they're trying to get through to that is a robust process of anonymization. You'll have to have measures with respect to the manner in which the data is anonymized and then the use or management of that anonymized data. And part of that management will probably include measures or efforts to prevent re-identification. And finally, everybody's favorite, record keeping, because you can't have laws without more records. Again, this falls to the person carrying out the regulated activity. You've got to keep records. And we will know what oh, go ahead.
Oh, yeah, just a question on this sort of these governance obligations. I'm just trying to think through, since we're both data privacy lawyers, a lot of organizations may already have built into their programs completing data impact assessments where certain processing activities present a high risk around the privacy of the data for natural persons. And I'm wondering, in your view, this sort of governance requirement structure is very similar to that data impact assessment process, which is look to see where it's high risk, complete an assessment where you can mitigate that risk through anonymization, keep records of that assessment. So do you see, in your view, that companies could really sort of see efficiencies by combining these reviews? Because I would think as you're assessing artificial intelligence programs and how they may impact natural persons, you are processing personal data likely in those systems. And so it seems to me, instead of doing one and doing a separate assessment, you could potentially combine in a broader risk assessment that covers both algorithmic impact and data privacy impacts. But I don't know if that's something that's workable in Canada. It's probably something you could do in the US, but curious on the Canadian impact.
I don't think it would be impossible in Canada, but I think there's slightly different approaches in terms of what's required under, say, a privacy impact assessment versus what's being contemplated here. The assessment as to what is a high impact system will be designated by statute. I expect a lot of the criteria will be similar. Interestingly, the privacy legislation that, again, the other part of this bill, C-27, would require a privacy impact assessment to be done and then risk mitigation processes put in place. This doesn't really speak to it. Artificial intelligence provisions essentially say once you're assessed as a high impact system, you're always going to be a high impact system, and you have to have these additional obligations and fences around you. But it doesn't speak to mitigating any of the, or lowering the fact. You can't ever not be a high risk or high impact system once you've been determined to be one. Next slide, please. The other bucket is around transparency, and this is a global theme we've seen. So there's publication requirements, and these apply to both the developers as well as the managers of high impact systems. So you have to publish on a website, publicly available, plain language description of the system that includes an explanation of how the system is intended to be used if you're a developer, or is being used if you're a manager, types of content that it's intended to generate, the types of decisions that it is intended to make or is making, again, if you're the manager, mitigation measures, and then our favorite language, other information is prescribed by regulation, so we will see where that goes. Also, not surprisingly, notification, mandatory notification in the event of harm. So if you have a high impact system, you have to notify the minister as soon as possible if the use of that system results in or is likely to result in material harm. and we don't really understand what material harm is. Harm is defined, material harm is not. So it'd be interesting to see what that threshold is, and the distinction of is likely to result in. No guidance on that.
Kirsten, question here as data privacy lawyers, all the links that we have on websites in California, you got do not sell my information, privacy policy, terms of use. Do you anticipate this being a separate standalone disclosure in a URL with a separate link saying artificial intelligence high impact system notice? Or do you think this is something that could be harmonized with, for example, the privacy policy? I know we just talked about previously that you see those as really distinct regulatory frameworks, but again, I'm just sort of putting on the company hat here and thinking, do I really have to add another link, another page that nobody reads? How do we combine these? How do we make it so, to be honest, it's more user friendly, because the more links, the more pages, the less people actually read. So what are your thoughts on this publication requirement and what currently businesses are already doing?
I think that's an excellent point. I mean, that's very good for lawyers like you and I who draft these things, but not good for anybody who actually uses them. I think in this case, the managers, in other words, the folks that are using the AI system, can probably embed that into a privacy policy with a specific call out, how we use artificial intelligence. That's also harmonized with Bill C-27's privacy requirements, which require disclosures around automated decision making, similar to what we see in Quebec's new legislation. I think it's a little tougher on the developer side, because there's a high probability on the developer side of things that they don't necessarily have a privacy policy, because they're not always going to be consumer or customer facing. It's likely to be B2B. And in many cases, they're not going to have considered that they're collecting or using privacy or personal information, and so wouldn't necessarily have a privacy policy. But yes, for those companies using it, I think that does make a good deal of sense.
I always like when you tell me that I make a good deal of sense. Best part of my day.
Yeah, well, we'll see what the people who draft the legislation think of this. Next slide, please. Oh, ministerial orders. Okay, so this is an interesting provision. This is where the structure sort of deviates from what we see in standard privacy legislation, including the Bill C-27 privacy provisions. This gives direct ability for the minister to tell you to do things, or to not do things, or to destroy things. And record collection, not surprisingly, you've got to keep those records. The minister can order that you produce them. And if you don't, they can then order an audit. And the audit can be done by yourself if the minister is feeling favorable to you. If not, you can be ordered to retain a third-party auditor. There's a concept here and a discussion about this third-party auditor being qualified to do so. And the government has floated the idea that maybe there should be a list of such qualified auditors, or at least some criteria by which these auditors should be qualified. So that one's a very good gift to the professional services firms. Note that the cost is borne by the audited entity, and I cannot imagine that any AI audit is going to be cheap. So that's a pretty big disincentive to monkey with the law right there. You're probably going to want to stay on side of it. If the cost and the audit doesn't deter you, the minister can then order that you stop, and it's the person who's responsible for the high impact system cease using it or making it available if he has reasonable grounds to believe that it could cause serious and imminent harm. So that effectively shuts down a business. There's also the right of publication. So the minister can make public on his website information about not only the high impact system, but also the results of the audit and any activities related to try and bring a company into compliance. Now, the only exclusion on that is confidential business information. And I didn't discuss that in the definition section, but that's also going to be an important definition. You need to understand what is or isn't confidential business information and govern yourself accordingly so that you can, if it comes to this, prove that something is confidential business information and keep it from being disclosed. And finally, that last provision there is kind of interesting too. It's essentially an information sharing provision, and it allows the minister to disclose information, and that is not ring fenced. That's any information that they obtain as a result these exercising these rights to other public bodies, such as the Privacy Commissioner, the Telecommunications Regulator, the Competition Bureau, or the Human Rights Commission. So you could be in a whole world of trouble here. For instance, if you did targeted discriminatory pricing based on prohibited grounds and then sent emails, you would trigger all of those. Each one is independent, and there is no sense, at least at this time, that any fines or penalties would be harmonized. So you have peril in each of those categories.
Kirsten, is there any room for cure in the regulatory structure? And just a counterexample, in California, under the current California data privacy law, you have 30 days to cure upon receiving a notice from the Attorney General's office before any enforcement action can happen. I see here sort of on the second bullet point, if the minister has reasonable grounds to believe you violated the law, they can order an audit. Do they have any requirement under the current regulation to send out a notice of non-compliance and engage with the company? Or is this going to be, you got a notice of non-compliance and an audit's happening and you don't have the ability to negotiate or discuss? How's that set up in Canada?
So that none of that language is found in this legislation. So there's no official cure period. We're a kindler, gentler nation. So if they act as they do with, like, say, the CRTC or the other listed entities there, typically what happens is you do get a notice of violation. You sit down with the regulator, have a conversation. Everybody agrees to resolve the problem. You shake hands, play a game of hockey, and off you go. So there is, it's sort of a cure period. There's usually a discussion and engagement. Obviously, if there is serious risk of imminent harm, that may be a substantially shortened period. But it's a procedural fairness and rule of law kind of approach to things that you have to have notice of this. And that's typical of our regulatory framework here.
So Kirsten, a question just came in that says, do you think the minister information could be accessed by anyone under STIP? So, and
I was thinking about that when I was doing this. It does appear that unless the regulations carve it out, access to information provisions would apply to information submitted to the minister. And I searched to see if that fell outside of that, but it is not. Now, I suspect that is going to be something that becomes an amendment or at least debated as this bill moves through, because that was a concern that I had as well. Next slide. And finally, the one everybody wants to know about is the penalty provisions. So there's all sorts of penalties associated with this. The favorite administrative monetary penalties, and then outright fines. And then if you still aren't getting the message, there's criminal offenses. Not surprisingly here, the fines look like what we see under the GDPR. Lots and lots of money tied to gross global revenue. And this is, if you breach these obligations, there is a due diligence defense available. So those of you taking notes here, that record keeping provisions are going to be important. You have to document this stuff. You have to show best efforts. The criminal offenses are interesting and new. The first one is particularly interestingly because it is tied to our privacy legislation, knowing use of personal information obtained through the commission of an offense under federal or provincial law. So that potentially triggers, if you've collected personal information without consent, you have violated provincial and federal privacy laws. And if you knowingly use it, knowing that you've violated that, you're suddenly into a criminal offense in the AI legislation. So that is something to be aware of. The third one, the causing substantial economic loss to an individual, is tied to an intent to defraud. So that gets us back into sort of the deep fakes and other deceptive types of advertising. And think there, for instance, if I put together a video where I have Peter Stockberger purported to tell the world that I am a great lawyer and you should send me lots of money, even though Peter didn't say that, I was able to use a deep fake to make him look like he said it. That's the sort of thing that might fall into that. So think celebrity endorsements. It's so weird that you mentioned that. That's my weekly LinkedIn video that I send out. So odd. Oh, well, you should probably stop that. Although thanks. So that's the Canadian side of things. Now, Peter, over to you. How does the U.S. make sense of all of this?
Well, thank you for that, Kirsten. I know I learned a lot. I think I know Canadian law, and then I feel like there's always a new federal bill. And I think that's one of the biggest differences between Canada and the US is this federal approach to things like artificial intelligence. In the US, we do not have a federal law that regulates artificial intelligence. Instead, like areas like data privacy and other areas of the law, it's highly sectoral and based on use of the technology with existing laws. So I think from a US perspective, I'm going to take a little bit of a different approach and focus more on the use of AI in different contexts and how the law in the US is developing around those contexts. And I'm going to be addressing AI in the workplace. So technologies used, for example, to select employees, go through job applicants, performance reviews, AI in offering services and products to the public. So in this context of a public accommodation, what are the laws developing in that space? And then finally, I'm going to touch on AI and data privacy, because in the US, data privacy laws are quickly growing at the state and federal level, and automated decision-making is being included within those statutory regimes. So we're going to address that there. And then finally, I'll put on a little bit of a prognosticator cap on and look ahead at what are the regulatory developments happening specifically to the use of AI more generally in the US. So we can go to the next slide and we'll kick things off on discussing workplace issues. We have seen a boom of use of artificial intelligence systems in workplace settings. The EEOC Commissioner Burroughs recently announced that nearly 80% of companies in the US are using AI systems in employment practices, which is a very significant number. And we see these technologies being used in a number of contexts. Probably the most prolific use right now is sorting applicants for jobs. These technologies, and there's a lot out there on the market, are able to look at resumes. They are being given a test resume or a baseline resume to build the code. And then they are examining other resumes based on past successful candidates to see language in those resumes and features that meet those past successful candidate metrics, and then culling down those job applicants to select potential interviewees. You then see AI being used during the interview process. There are video interview systems that are reading things like Kirsten, you and I were just talking about. Are you smiling? Do you have optimism in your voice? So these systems are determining based on behavioral analytics as to who would be a good candidate, who may not be a good candidate. And then we see AI being used in the actual employment process itself in performance reviews. There are AI systems on the market that can look at objective features of performance and spit out a performance review that the employees can receive. So AI is being used in a number of respects in the employment space. From a regulatory and legal perspective, the law is still catching up to this practice. The first law we saw in the books that governs this type of use is in 2019, Illinois passed what's called the Artificial Intelligence Video Interview Act. And this law says that if you are going to use that technology in the interview process, that sort of second bucket of AI use, you've got to give the applicant notice and get their consent to the use of that system. So it's a notice, it's a transparency rule, really, that was passed in Illinois, first of its kind. Maryland followed suit and really restricted the use of facial recognition services during those interviews. So similarly, on that second bucket of use, trying to mitigate bias. Recently, New York City has an ordinance that takes effect on January 1 of 2023 that restricts the use of these automated decision tools and requires a bias audit before launching those tools. And this is a term of art that we're seeing more and more in the US being used. And it's very similar to that governance slide you had up, Kirsten, which is auditing the system to mitigate biased outcomes. So can you remove certain features of the algorithm to mitigate a biased outcome? And here's an example of a biased outcome. If you train, for example, your AI system on resumes and you train it on past successful candidates, but past successful candidates were predominantly, let's say, white males, then the resumes that you see that, for example, list women in sports or language about non-white male dominated areas, they may call out those resumes as not aligned with the previous resumes. So you can see where biased outcomes can be inadvertently built into the system depending on how the algorithm is taught. And that's what these laws are really trying to address. Here in California, because we are never one to be outdone by regulation or laws, the Department of Fair Employment and Housing, which is the regulatory body charged with enforcing California non-discrimination laws here in California, they are proposing regulations to limit the use of AI in employment that would result in discrimination on the basis of a protected ground. So the trend here that we see at the state and at the local city level is developing regulations that limit the ability of the use of AI that would result in a biased outcome. That's one feature of these laws. Another feature is notice and consent. And I think we're going to continue to see these being developed. Washington, D.C. also has a similar pending legislation, the Stop Discrimination in Algorithms Act. So it is something that's really growing. 17 states in 2021 had proposed legislation around this similar issue.
That's fascinating and very different than the Canadian market. And just a quick question: if you're a national employer, if you're based somewhere or two somewheres, and you're hiring nationally, how do you manage those multiple state laws based on where your candidates are, based where you are? How does that all work?
So these laws are all going to generally apply to the individual who's a resident of that state. So if you are a multinational employer and you are hiring an individual in Illinois, you're going to be subject to the Illinois law. Same with New York City. If you're operating and hiring folks in New York City, you're going to be complying with that law. That's generally how the US employment laws work, is it's focused on the location of the individual, not necessarily the location of the organization. But to your question, Kirsten, how do you develop a compliance program that can meet all 50 states developing? And the short answer is it's difficult, but what most companies will do is if they want to apply a single standard across the board, they will take the most restrictive standard and apply it across. And so in this context, if you were going to take just what's on the slide here, you'd say, well, we're going to have notice and consent around any use of AI in the employment process. And we are also going to conduct bias audits to mitigate biased outcomes in these systems. And that may get you over the line in most of these states and may satisfy the requirements of other states as they come online. But just to step back for our Canadian viewers on the system, for those not familiar or want a civics refresher on the US system, this is very similar to how other areas of the law are developing. For example, in data privacy, it's happening at the state level and it's happening at the local level. It's very difficult in the US to get a federal law passed for political reasons, but also because these issues are largely state by state issues, and the states are very proud of their approaches to these issues. So Illinois, for example, is on the cutting edge of regulating things like artificial intelligence and biometrics. New York City has a biometrics law on the books and now an artificial intelligence law. California is always chasing as well. So what you see on the screen here really matches with what's developing in other areas of the law as well.
So Peter, you'd mentioned that, I think it was the Illinois one, that you can only do the AI video with consent of the candidate. How does that work? Does that mean if I, as an employee, a potential employee, don't consent, does it end right there? Or do I then go to a manual process, an old-fashioned process? Or do we know?
Yeah, I think you can, if the individual refuses to participate in your hiring process, then that can be a prerequisite for hiring and termination. Because at that point, you are not stopping the interview process based on a protected characteristic. You're just saying you're not going to participate. There are some of the state bills that are talking about that you have to give people the option to not engage in it and still proceed with any process. So it is something to watch at the local level. But what we're really seeing an interesting development is around the federal guidance. So just a few months ago, the Equal Employment Opportunity Commission, the EEOC, which is the federal agency charged with interpreting and enforcing Title VII of the 1964 Civil Rights Act and the Americans with Disabilities Act, the ADA and Title VII. Title VII prohibits discrimination in the workplace broadly on protected characteristics. The ADA specifically prohibits discrimination on the basis of a disability. And the EEOC, as well as the Department of Justice, which has civil and criminal enforcement authority under both statutes, Title VII and ADA, they both came out with guidance cautioning employers about the use of AI in employment practices in a way that would violate the ADA. And their guidance tracks what we see at the state level. It even tracks what you've outlined in the Canadian law, Kirsten, which is don't use this in a way that could result in a biased outcome, that could result in discrimination. And so you've got to interrogate the components of the system before you use it. And that's really my key takeaway here around workplace use of AI is the laws continuing to change. But if you are using any of these systems, including if you are outsourcing this and using a vendor and sort of setting it and forgetting it, you have to do the due diligence on the system. You have to ask the hard questions of the vendor to say, what are you doing from a policy perspective to mitigate bias outcomes? How does the algorithm work? If you remove a protected characteristic, will it still operate the same? That's a lot of the test. Because if you remove a protected characteristic from the algorithm and the algorithm no longer works, that could be a tell that that protected characteristic is a guiding factor in the system, which could lead to a biased outcome. So that's really the key takeaway here is you can use these systems, but the law is starting to coalesce around preventing bias in the use of the systems.
Yeah, I think that it would become important then in all contracts with potential vendors to really have robust indemnification clauses and reps and warranties around testing and audit and bias-free requirements.
That's exactly right. And you see that's pretty commonplace in a lot of contracts already, but when you are buying stuff off the shelf, a SaaS platform, you'll see their terms are obviously going to be written in favor of the platform provider. So, but having that as part of your corporate compliance checklist when you're reviewing vendor contracts to say, do we actually know how this was built? Do they have a public facing statement of algorithmic ethics, algorithmic transparency? Those are all things that right now corporate compliance departments aren't necessarily checking. And I think the law is developing here where it's becoming an imperative to look into those issues. We'll go to the next slide and we'll talk about the next sort of category, and this is around public accommodation. So this focuses on the ADA as well, but there's a separate portion of the ADA, and there are state counterparts to this in the US, that say if you are offering a public accommodation, which is now being interpreted to include websites, any service or product you're offering out there, that's a public accommodation. You're bringing the public in. So for example, in the US, we see a proliferation of lawsuits alleging websites not being compatible with the ADA because it doesn't have, for example, screen reader technology, or the color contrast isn't sufficient for people with viewing capability issues. And so the ADA has this public accommodation requirement. So the question is, what is a public accommodation? What is discrimination? The states have counterparts that say, if you are offering something in the public, you cannot discriminate on the basis of a protected characteristic. And a classic example at the state level are these ladies' night cases, where bars and restaurants will host ladies' night, and then they're sued saying you are discriminating against male patrons in your public accommodation. And those lawsuits have been successful because the law is written in a way that says if you are offering a public accommodation in a different manner to different groups of people based on that protected characteristic, it could be a violation of this law. And that's why, Kirsten, I had asked you earlier about the Canadian bill. Well, what if you're offering it in a way that's positive, that is supposed to be lifting up the community? The Canadian bill has nice language that says that's okay. The US laws don't have that carve out. The ADA was written in 1990 before these technologies were available, and the state laws are fairly strict in how they're written.
So that's a very good example of something that may be entirely legal on one side of the border, but prohibited, outright prohibited on the other.
Yeah, I mean, it could. And when I'm counseling clients around the use of AI, so getting back to how does AI sort of tie into this? Well, if you are offering, let's say, a coupon or a discount, or you're pushing out marketing for a particular product to a group of people based on a protected characteristic, gender identity, sexual orientation, race, ethnicity, national origin, based on different language. If you're sending it out to a Hispanic community in the US in Spanish language only, are you offering something to the detriment of another group? Is it a different offering? And arguably you could look at the law and say, well, it's black and white. Yes, that would be arguable discrimination. But then I always put on, Kirsten, the risk hat, which is, okay, if we get into a lawsuit here, what jury is going to get upset about a communication in Spanish versus English? And I guess it depends on the part of the country you're in to see whether a jury would be upset about that. But that's really the push and pull here in this space of the law, which is, and it ties into the first part around employment, is in your offering of services, coupons, digital services, communications, marketing, are you making distinctions in groups based on protected characteristic by using algorithmic intelligence, artificial intelligence to push out those systems? And if so, I recommend all companies look at that and say, is there a biased outcome? And if we remove that protected characteristic from the program, will the program still work? I'll give you an example. In California, the law says that the Discriminatory Act has to significantly have a discriminatory impact on an individual. And significant is not defined. So if you remove the protected characteristic from the algorithm, if it still sometimes works, but it doesn't always work, those are difficult questions. Those are gray areas of the law right now. So the key takeaway here is you've got to be diligent in examining the underlying automated decision-making that is generating anything that's being offered to the public. And that's really the key distinction. There's a couple of questions in the Q&A box that I'll run through before we go to the next section. One is, if the person is a citizen of the state, but he or she is not at the moment located in the state when applying for a job, so this goes back to the prior slide, does the regulation of the state apply to that employee still? And generally in the US, employment laws apply to where the person is performing the work. So usually that means the person's a resident of the state because they're performing work there. It does get a little complicated when, for example, you're a resident of California, you've gone to Texas temporarily to perform work. Are you subject to California laws because you're a resident, or the Texas laws? Generally, the Texas laws would apply because you are actually performing work in Texas. Another question says, how can you correct some AI biases? For example, if all your hiring has historically been for whites from a local college, how do you get the AI to potentially hire people of color from smaller or out-of-state colleges? And the key there is the training of the AI, that step, because humans are training the algorithm to look for certain features and make measurements, make recommendations based on those features. So if you are just giving the AI system a baseline resume without any qualifications, without saying this language should also be looked for, this language should also be included, don't exclude resumes that don't say male or don't appear male, that teaching of the algorithm is where you catch it and where you can mitigate the risk. That's my judgment. Kirsten, I don't know if you have a different view from the Canadian side.
Yeah, it's very similar. You can use sort of weighted probabilities. In other words, you attach more weight to certain characteristics than others, and that helps. But obviously, you need to do extensive and rigorous testing. A very good example of this is in the tech context, where there is a shortage of women in tech. And the use of these types of algorithms is obviously going to be based on an existing workforce, which skews heavily predominantly male. So rather than alleviating the issue, which is what these examples were designed to do, it actually compounded the issue.
Yeah, that's a great point. And that's the difficult challenge here is finding that balance. And right now, unfortunately, in the US, the law doesn't give you that answer. So there's a lot of judgment calls to be made. And we'll go to the next slide to talk about the sort of third bucket of AI in the US, and that's around data privacy. Data privacy is a topic that is completely exploding in the US, largely at the state level. For years, data privacy in the US, I think, was sort of an afterthought. We had some federal laws that regulated it in healthcare, in financial institutions, HIPAA and the GLBA. And at the state level, it was largely driven toward the use of minor data and some disclosures that you needed to make on your website. In 2018, California became the first state to adopt what's known as sort of these omnibus data privacy laws called the California Consumer Privacy Act, which gives California residents broad rights over their data, the right of access, the right of deletion, the right to opt out of it being sold to third parties. And since 2018, a number of states have tried to copycat California and move along. It wasn't until this year that more states came on board. So starting in 2023, we have omnibus consumer privacy laws, an update in California, Virginia, Colorado, Utah, and Connecticut. And in a number of these laws, including in California, they make specific reference to automated decision making. And in some of these states, there is a right to limit automated decision making, which mirrors the right that exists in Europe under the GDPR and GDPR-like countries. And so what does that mean for businesses? What is automated decision making? What is that right and how is it going to be exercised? We don't know, because right now we're in the regulatory drafting process for a number of these states. Virginia has already completed their process. They didn't address the issue. Colorado is in the midst of taking public comment. There will be hearings later in the fall. We'll see if they address automated decision making. California, the new privacy enforcement agency here called the California Privacy Protection Agency, the CPPA, they have announced they will not address automated decision making in this round of the regulations. There's also ambiguity under the law whether there is a right to limit automated decision making. So the short answer is that in addition to the laws at the federal and state level governing the use of AI in employment and public accommodation, you also have to be cognizant of how these systems are processing the personal information of residents of these states. And an example of this is if you are testing, building, teaching your algorithm with information that ties to an individual, which inevitably you will need to do because otherwise the systems can't learn. Are you doing it in a way that's reasonably limited to why you collected the information? Does the individual have adequate notice? Do you need to get their consent to process it? And will you have the ability to stop that process and remove their data from the algorithm? Those are all open questions under these state privacy laws. There are also federal privacy laws that are gaining steam. There's a federal privacy bill that now has bipartisan support. The big sticking factors under federal law were around the private right of action and the state preemption question. Those have been resolved at least on a surface level bipartisan basis. I don't think that bill is going to get passed before the midterm elections here in the US in November. So depending on how Congress shapes up, we'll see if that bill makes it through. But again, key takeaway here is you can't ignore the impact on data privacy when looking at your automated decision-making systems and thinking about how you mitigate risk. We'll go to the next slide. So finally, this is the sort of outlook of where we are in the US. I mentioned earlier, we have 17 states in 2021 that introduced specific AI regulation. Most are focused on mitigating bias in the use of AI in employment, in offerings to the public. There are some laws that regulate, for example, insurance companies and how you can use AI to determine coverage or rates. There is a federal algorithmic justice and online platform transparency bill. It was one of my favorite hearings to watch, the markup of the bill, and just watching all the politicians ask questions about the algorithms. There was a great Saturday Night Live skit where one of the actors was like, now how big's the algorithm? Is it this big? Is it this? Well, that's a big old algorithm. which was not far off from how the hearing was conducted. So whether the federal bill is going to adequately capture the use of AI, we'll see. It is focused on mitigating bias. So we're back to that original kind of theme, Kirsten, which is mitigating biased outcomes. We've got the EEOC and the Department of Justice with their recent guidance around the AIDA. Another important development that's happening is the US Department of Commerce has an agency called the National Institute for Standards and Technology, NIST. NIST is perhaps most famous for issuing a privacy framework that a cybersecurity framework that many companies align themselves with to be seen as baseline reasonable. So they adopt the NIST controls, and NIST sort of issues standards and guidance for industry around items related to technology. They are right now taking public comment and hearings on developing an AI framework to mitigate bias, to mitigate risk, best practices on transparency. So keep an eye out for the NIST framework, because if that NIST framework gets developed and released, you may see a lot of legislatures benchmarking reasonableness to the NIST framework. So you may see, okay, well, I comply with the NIST framework around mitigating bias. I align myself with it. Therefore, I mitigated bias under the California regs for the DFEH. That's, I think, an important sort of guidepost here in the US to watch out for. But the key takeaways here, you just got to keep watching this space, because the states are continuing to develop these bills aggressively at the state level. I know we have a few minutes left here to address some of the additional questions in the Q&A box. And Kirsten, here's one for you for Canada. I mentioned the issue around training the AI with how you're training on the resumes. Is that the similar issue in Canada, the training of the use of the AI, and how would that be addressed in Canada?
Yeah, that's interesting and kind of a gray area right now, because it would trigger both laws. It triggers the privacy law, the existing one, and likely the future one that's in bill form, and it would trigger the AI bill, AIDA, assuming that was passed as well. It's an open debate right now whether or not consent, express consent, would be required to use personal information to train an algorithm. If you're doing that right now, you should at least disclose that in your privacy policy, public facing. And then, of course, we get to if there's a right of deletion or right to withdraw consent, if I no longer consent to having my personal information used to train an algorithm, what then? It's not like you can unscramble the egg.
There's another question that just came in around what powers and authorities do these new laws provide for uses of AI by public authorities like the SEC or FINRA, public enforcement authorities. And these laws at the state level, there are laws being introduced to regulate the use of AI by state agencies in their practice. At the federal level, there aren't regulations that regulate their use. And so that's an area you have to watch out for. And these agencies are free to use algorithms to assist in their enforcement activities. There are some other questions in the Q&A box. Perhaps we can reach out to folks offline. I know we are up on time. So on behalf of myself and Kirsten, thanks so much for joining. And we're obviously available to answer any questions or if you'd like to continue the conversation. Thank you very much for your time and your attention.
Thank you, everyone.